Well, I don't know. You know, usually at the Supreme Court, I get 15 minutes as an intervener, 45 minutes as a respondent, and an hour as an appellant. I have 5 minutes to explain to you the Bank of Canada lawsuit. If you don't know about it, you're not going to get it, an explanation from me, okay? Essentially, in very broad strokes, the lawsuit, which was filed in December of 2011, is a constitutional challenge to the Bank of Canada and the Minister of Finance in refusing to give interest-free loans to the federal and provincial governments, which was the central reason the bank was set up initially in 1937. That was the reason the bank was set up. So these loans could be given to the federal and provincial, and at the time directly to municipal governments, for up to a maximum of 1/3 of their annual budget, so long as that 1/3 was paid back the next year, which, if you look at the numbers, is easier to do. And so this is how historically we paid our World War II debt. We paid for the Trans-Canada Highway, we paid for the St. Lawrence Seaway, and we paid for the explosion of the building of universities in the 60s and 70s across the country. So that is the first, in a broad stroke, challenge to compel the two levels of government to request and to rekindle the primary purpose that the Bank of Canada was set up to do. And it's couched in a lot of different constitutional challenges. Also challenged is the joining of Canada to the Bank of International Settlements, and everything you heard from Ellen Brown there is pleaded in our case, the history of it, in terms of our being linked with the BIS, the IMF, and all the other foreign private bankers who actually give our public bank, the only public bank in the G20, its marching orders. The minutes and the minutes of the meetings that our bank governor has with these other bankers, even though he reports to the Minister of Finance and Parliament, he claims are held secret and we're not allowed to know the content of those meetings. That's also being constitutionally challenged here. We're challenging the government for relinquishing and advocating its constitutional duty to govern under various provisions of the Constitution Act. The other part of the challenge, which goes hand in hand with this whole banking fraud that's going on, is against the Minister of Finance and the budgetary process. What happens in the budgetary process every year, which is a constitutionally required process where, you know, they all dress up in medieval clothing and they knock on the House of Commons for the speech from the throne. That's actually a constitutional requirement. Since 1215 in the Magna Carta, because only Parliament can impose taxes, Parliament will not impose taxes, cannot impose taxes before the government tells the House of Commons how it plans to spend that money in the next session. And so it's a requirement. The speech from the throne is a constitutional requirement before the budget is actually passed. Problem with the budget in our country is there's a sleight of hand that goes on, and that is, just to give you an example, they'll say, you know, that our expenditure needs are $280 billion. We're going to have revenue of $240 billion. Therefore, we need to borrow $40 billion, and that's our deficit for the year. Well, that's not true. They collect or could collect a lot more than that, but then they transfer back to taxpayers, running from everyone from the single mother or single parent to mega corporations. They transfer back money in tax credits. And then they say, we have $240 billion, we need to spend $280. And why is that significant? That's significant because if they're collecting $400 billion, the MP should know that, because then they can have an intelligent, if they're capable, I don't know, maybe half of them couldn't do it, but if they could have an intelligent debate on whether or not they want to run a $40 billion deficit or shave the tax credits and run a balanced budget. And so that's a very nasty sleight of hand that's going on with our budgetary process, which we say is unconstitutional. Now, it's coincidence. I don't know if it's coincidence, that since 1974, when the last interest-free loans were made to the governments to meet their budgetary needs, every time we've run a deficit, it's been very close. It's been very close to the interest payments on our debt. So usually, if you look at a budget, usually the deficit that's run in deficit years is to finance the interest on the accumulated debt from deficit to deficit. It's like the old opium wars in China. We've been forced on an interest addiction from the banks. Now, the reason they say that they don't want to make interest-free loans from the Bank of Canada is they claim, Minister of Finance perpetually claims that there'll be an inflationary pressure, which is a metric ton of horseshit, because the Bank of Canada, and especially the Federal Reserve in the last few years, the Federal Reserve has been given interest-free loans to the private banks. Our primary lending rate is 0.75% as of this week. So the private banks get their money from the Bank of Canada at less than 1%, and they lend it back to our government at 3.5%, and we pay the bill. So if the Bank of Canada giving money to the private banks at nearly 0% isn't inflationary, why would it be inflationary if they give it to the government? Because it's going to be paid off in the next fiscal year anyway. And so basically those are the two broad stroke challenges. The statement of claim runs about 25, 26 pages. I mean, it's more involved than that. You have to set out what's going on. At the first level, the government brought a motion to strike the whole claim, saying it was not justiciable, that the courts didn't have the right or the expertise or the wherewithal to hear the case. It was struck. I appealed that on behalf of the plaintiffs. I was successful at the second level, where the court said, well, we had nominally sued for $1 for every Canadian on a class action. The court said, forget about the tort and the damages, but you can pursue the constitutional declaratory relief with respect to how they're managing the bank and with respect to the budgetary process. The government has appealed that. I've partially appealed part of the order. What the judge says, I'm going to strike these portions, but not these portions, but redraft the whole statement of claim. I don't want to redraft the whole statement of claim because I don't want to go for another round of a motion to strike. I'd rather proceed on the constitutional relief. So on Monday, we're before 3 judges of the Federal Court of Appeal to determine how much of this, if any of the case, is to go forward, because the government has appealed the order that the constitutional relief can go forward. And so we'll see what happens on Monday. I'm not a pessimist, but I am an optimist with too much experience, so I'm not going to predict. And from there, it's likely to go. If we lose, we go to the Supreme Court of Canada. You need permission. If the government loses, I know very well that they're going to seek permission from the Supreme Court. So it'll have to go to the Supreme Court of Canada to decide whether the case actually proceeds, and if so, to what extent. So this is why cases don't get litigated in Canada. We're going to the Supreme Court in order to determine whether or not my clients can proceed in court. And this is very typical of all government cases that I do. We go through this round of motion to strike. All right, so that's in a nutshell the case, and I always make my presentations brief because I find it more beneficial. If people have questions on it, I'm happy to answer it.